Whether you're an e-commerce entrepreneur or just someone with a brilliant idea, understanding trademarks can be a game changer for your brand.
We're going to break this down. We're going to get into the ins and outs of what trademark is, where the hangups are, kind of walk you through this process.
People come to us saying, we've already done a search, we've searched Google, there's nothing else out there. Like, okay, we hope you're right, but let's do our deep dive search. And then inevitably, we always come up with other things that the Google search didn't find. They'll come to us and say, I saw a company that has the same sort of similar name, but they used an S instead of a Z, so I'm good, right? And it's like, no, it's completely the opposite. Those are the very things that we're looking for.
There's 45 classes for goods and services, and that can really cause a lot of problems for our clients.
Filing a trademark application for the proper class, which loses you a lot of time, of course, because it's taking about 9 to 12 months for it to even reach the USPTO examiner's desk.
All right, we've made it through this far. We've now gone through publication, we've gone through opposition, we waited those 12 weeks. We're registered. That's it. We've got it. We're done. We need nothing to do, nothing more.
Wouldn't that be nice? So no, once you're registered, there are...
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets.
Welcome back to another episode of Securing Your Brand. We are your hosts. I'm Holly.
And I'm Melissa Jeda. We are here today to dive into a very crucial topic. We are going to look into what establishes your brand in the marketplace. How do you stand out by using a trademark?
That's right. Whether you're an e-commerce entrepreneur, a small business owner, or just someone with a brilliant idea, understanding trademarks can be a game changer for your brand.
We're going to break this down. We're going to get into the ins and outs of what trademark is, how you trademark, where the hangups are, and kind of walk you through this process. We're going to discuss what is essential so that you know how to protect your brand.
Plus, we'll tackle some common misconceptions about trademarks that could be holding you back from taking that next step.
So, if you're ready to learn how to safeguard your brand and stand out from your competition, stick around as we go through it in this episode.
Let's get into it.
All right, Holly. Before we actually register a trademark, what is a trademark? How do we do this?
So, a trademark is anything that identifies your brand. So that can be your business name, your logo, slogan, designs incorporated into your business, anything that identifies your business brand.
So really, it's what makes my brand my brand. It's what makes my company stand out from the rest of the companies, so I am not recognized as a different company. So building that brand is super important. Making sure that you have a trademark that is protecting your brand, protecting your reputation, not only gives you more credibility, but it also stops others from infringing on your brand. So how do we get started with a trademark, Holly?
We begin by doing a comprehensive search of your brand name or your logo, whatever it is that you want to trademark. We do a comprehensive search, searching to make sure that there's no other business out there that is using that name or that logo or that slogan that would create a barrier to prevent you from being able to register and protect that brand.
So once you know that you can own that name, we can have a trademark, we've done the search, we've taken a look at it, we've talked to you about it, that search is going to tell you who else is out there, right?
Correct. That'll tell us not only other companies that have registered trademarks, but also any company that might be using that name in an unregistered basis, which in the legalese, we call that common law trademark rights. Those common law rights are more limited than official registered trademarks. However, they are important and relevant to be reviewed and analyzed prior to making that decision to file for a trademark registration.
I can think of a couple of times where we've run a trademark search and we're like, oh, that's such a creative name. There's no way that's being used. We would have heard about it. And we get that trademark search back and we're like, now we got to give the client bad news and say, this company exists and they, exist for the same services. It's like, it's so disappointing.
Happens all the time, right? People come to us, saying, we've already done a search. We've searched Google. There's nothing else out there. We're like, okay. We hope you're right, but let's do our deep dive search. And then, inevitably, we always come up with other things that the Google search didn't find.
How do we do that search? Can anyone do that search? Can we all run that search?
USPTO, the United States Patent and Trademark Office, has a trademark search feature on their website that is public and open and available to everyone. But it's not so simple to do a search like that. It's not like doing a Google search. It's a lot more technical. You have to know what to put into that search to get the proper results out of it.
The USPTO search engine is actual. It is looking for like what you actually put into it using our brand name, SecureMark Legal. If you were to search SecureMark Legal and you were to use, a C instead of, an SEC, and you were to use an SO, you may not come back with SecureMark Legal. It may not turn up a result for you. It may just tell you, yeah, there's no other confusingly similar marks, or there's no marks, or give you no report. And that's not necessarily true because we know we're a registered trademark. So the complication in using that search engine without knowing how to search it for everything, phonetically, what we call fuzzy. So we're using it every form of every vowel. If it got an S sound in your name, I'm looking at Z's and TZ's and Y's and C's, and even maybe a combination of a CK or a CH, to make a S sound, because anything phonetically similar could be confusingly similar.
Right. And that's something that a lot of people have a misconception about as well. They'll come to us and say, I saw a company that has the same, sort of similar name, but they used an S instead of a Z. So I'm good, right? And it's like, no, it's completely the opposite. Those are the very things that we're looking for. When the examiner at the USPTO looks at your application, they're going to look at all of those similarities, and anything that has a similar commercial impression or even is just likely to confuse the general public, which is a very, very broad subjective standard. Anything that could cause that sort of confusion, the examiner will say, nope, you can't do it. It's already out there, even though it's not identical to the mark that you are looking at registering now.
Okay, so we're kind of jumping ahead. We're talking about an examiner. But before we get to the examiner, we really have to get through this application process. The application process, if you're registering your mark in the United States, is done through the United States Patent and Trademark Office. And that application is pretty straightforward. It's right on the website. It's click, fill in the blank, put it all forward. But we definitely see some hangups with clients when they fill them in. They've come to us after and they're through that step and they're at the examiner, which we'll talk about next. But they're filling in that application. We've definitely seen where they get caught up in two major places. We see them get caught up both in their class and in their description. There's 45 classes for goods and services, and that can really cause a lot of problems for our clients.
Yes, because it's not always obvious which class your business belongs in, and you could very well be in more than one class. And it is important because when you choose your class, that is the category that you are claiming your trademark rights in. You won't necessarily have expanded rights into other classes if you choose the wrong class from the beginning. And if you do that, sometimes we are able to fix that mistake and sometimes we're not. If you choose the completely wrong class from the beginning and later on down the line when the examiner reviews your application, they say, no, you should actually be in this other class, you would be looking at essentially starting all over again, filing another trademark application for the proper class, which loses you a lot of time, of course, because it's taking about 9 to 12 months from the date of application for it to even reach the USPTO examiner's desk.
Yeah, that's a long time. Not only are you losing that, you have to pay for the application again. It's a fee per class. If you have to make corrections, there's another fee now with all the fee changes that happened this past January. So we have all these additional charges that result in when you make a mistake in your application. Instead of it was before, oh, okay, let's fix it. Let's expand the class. Let's pay for the correct class. We'll pay again and we'll go on with the application. But now I don't know if the USPTO is calling them mistake fees, but I think I'm going to call them mistake fees because it's a little bit ridiculous that you miss something small and the USPTO is going to charge you an additional fee for that kind of thing. And the fees, they can start adding up. It's per class. So if you're in 2 or 3 classes and you're being charged $100 to fix each mistake per class, that adds up really fast. So that's another, kind of cautionary area that we haven't even branched off into yet. And it's difficult to determine where your class is. Are you a downloadable or non-downloadable podcast? I mean, even just talking about our podcast, you can be in multiple classes. It seems like this is a service, but is this a good? Is this a service? Are we providing, legal advice through this process, which we're not, but all of those are different classes. So it gets quite complicated quite quickly.
Yes, it does.
The other area that we see a lot of problems in is description.
The description that you put in your trademark application, that's the description of the goods or the services that your company is providing. It may seem obvious when you're filing it that you think that you know what your business does, but we base our class descriptions off of our comprehensive search partially. Based on what we find in that comprehensive search, we may, for example, find that there are other companies that are using a similar name in the same class, but with a little bit differences in their goods that they're selling. So, for example, if you're in the clothing class and you are selling primarily t-shirts and hats, there may be another company out there that has a similar name that is very, very specialized in, let's say, cowboy boots. If we find in our search that that is such a very specialized area of only cowboy boots, and it's mostly people in the country western sphere, or that are looking for that type of brand, we may decide that it is maybe safe for us to apply in this t-shirts and hats category, maybe excluding cowboy boots. That's just an example of how you may file your application and say that you're filing just in clothing. And if you list only clothing, those cowboy boots could be a conflict with just clothing. But if we're narrowing it down to a specific type of clothing and not including cowboy boots, that could be a distinction that could make the difference potentially between your application being denied or accepted.
Yeah, that change can make a big difference. It also, if you go too narrow, you can end up being limited to what other people do and how other people can use a similar name to you. But you can't actually go too overly broad. So it's kind of this fine line between describing what the goods and services that you do and not making sure that you're offering enough protection so that have no one else coming back and infringing on you. It becomes this kind of gray area. And we tell our clients everything is very subjective. So it's this kind of difficulty to narrow it down to exactly, hey, this is what you're supposed to do. This is how it is. But it also means you have to be selling or providing that service in commerce. So you have to have already know that you're going to be an intent to use application, what you're going to intend to, sell or provide. And you have to be selling that in commerce in order to get a trademark application. So you can't just be so overly broad that you're saying you're selling the world, because nobody sells everything or provides every service. But at the same time, being too specific and saying, I'm only going to provide silver tip cowboy boots, you're never going to branch off into something else. It's a problem. But going back to that again, you also have the same thing with the classes, because though you provide, or you're selling cowboy boots, kind of like staying on this topic, though we're providing cowboy boots and all we're doing is selling cowboy boots and we're in the Western field, maybe we're going to branch into buckles later. But there's a similar name in the music entertainment category. Could that be confusingly similar also?
It could potentially. Again, it's very subjective. So the examiner could look at it and say, country music. Country music performers wear cowboy boots, right? So
I like to tie those things together, put it into this realm of expansion. How much can we tie into this, put everything in together into one class?
And this is an example of, the type of work that attorneys do in the trademark realm. If we get a refusal from a trademark examiner, let's say they expand it widely into country music, and we believe that that's a little bit over the top, we can make arguments against that. You don't have to accept what the examiner says right off the bat. If we do our legal analysis and we don't agree, it's essentially, one attorney against another, their side against our side, and we can do legal research and write up a legal brief to oppose what the examiner says. And, a lot of times we do prevail on that.
So that's a good segue into the next step. So you got to do your trademark search first. You got to make sure you can clear the mark. Got to go through the application, making sure we list the proper classes. So we're on to the third step here, which is office actions. So that's when the examiner gets assigned, and Hallie's talking about an office action here. There are some common office actions, one of them being this 2D refusal, that there is another confusingly similar mark that the examiner has found, and that mark may be within the same trade channel, in a different trade channel, in the same class. You may have arguments as to why that mark is different than my mark. It can be that my predominant word is different than their predominant word. Yeah, we share some of the similar words, but my predominant word, my main word, for the mark's main word, is different than the one you're citing. It may also be that we're a different class, a different category of goods, a different trade channel, which really is the consumer. So the consumer is not going to be confused by looking for, coming into a store to buy cowboy boots and think they're coming into a store, for solar panels. They're two different, types of consumers. They're looking for two different types of goods. So it may not be so confusingly similar on the face of it once we start digging into it and, going back and forth with the examiner in regards to that office action. There's a couple other office actions I think we find really common. We get the wrong description of goods and classes. I think that one's really common. We also get disclaimers a lot, whether or not we're going to disclaim a word for part of our mark.
An example of a disclaimer would be our law firm, SecureMark Legal. The whole name SecureMark Legal is our trademark. We have a trademark on that whole name as a whole. But legal had to be disclaimed, and we knew that from the start. We didn't make any argument against that because it makes sense. Legal describes exactly what we do. We are a law firm. So disclaimer just means that you can't claim trademark rights to that word alone, not connected to your mark as a whole. So we can't prevent another law firm from using the word legal. Of course, that would be absurd to try to claim rights to the word legal.
But not all the times we agree with the examiner that, sometimes when you're using a word and they're saying it's descriptive, but it's not descriptive of the services I'm providing. It's descriptive of other services, and I'm not using it for that purpose here. So not always do you have to disclaim words that are descriptive. It kind of depends upon if it is descriptive of the goods or services that you're providing. I can't claim exclusive use over that word. Medical, if I'm a medical firm, but medical, if I'm, selling sports drinks and I want to try to get away with using medical, maybe it's not, because it's not a medical product.
And another example that we love to use is Apple. Apple for computers, they have a trademark on the name Apple. If they were selling apples or apple juice or apple cider, apple pie, they wouldn't be able to claim trademark rights to the word apple. So that's a good, example of that descriptiveness. We're not describing apples, we're describing computers, which is completely unrelated.
That's a really great example of how a general term can be used for a brand, as so long as that brand is not selling that general term or providing the service of that general term. So it really makes it a creative name. Creative names are a lot easier to trademark, a lot easier to continue to police that brand and control the brand going forward. The other office action we see a lot of, so we see a lot of confusingly similar, we see a lot of disclaimer, we see a lot of wrong class, wrong description, but we also see a lot of translations. Having a mark, an office action for a translation and not describing that translation in the front. Again, now you're going to get fined for that. If you don't define that translation in the beginning of your application, where that translation comes from and what language. So translating that word from another language into English and the meaning of that word in English for part of your trademark. Now, your brand isn't changing. Your name isn't changing. The translation is now part of your trademark registration. It's not changing the description. It's not changing the brand name. It's just that translation is now part of your registration. And translating words. How do we know that words are supposed to be translated? That's so complicated.
And how do you know that you're finding all of the possible translations in the world? How many different languages are there in the world? Thousands?
There's a couple that we've looked at and we've been like, huh? Where did that come from? If it
Yep.
is common, if it is a known translation, it should be included as part of your application. Now,
Mhm.
if your mark did not intend to translate it, the translation does not make your mark make sense, does not make your brand and name make sense, then maybe there is no intention to ever trademark it. So it is just a word to you. It's just part of your mark, and it has no translation in another language. Then you don't necessarily always need to translate it, but that's going to be an argument to an examiner every time. Okay, so we've made it through the search. We've made it through the application. We've talked about the common office actions. Got a couple more steps here. After you get through an office action and the examiner finally agrees with you, we go to publication. Publication is a process in which the USPTO publishes inside the Trademark Gazette. And inside that publication, anyone can oppose your mark if they feel that you're not entitled to registration. Who opposes marks? Who opposes another brand?
I mean, it could be anyone. Most often, it's someone in your industry that sees you as a competitor and doesn't want you to come in and use that mark to compete against them. And sometimes they may have a good argument. It may be a brand that you didn't know about before you filed your application. If you filed it on your own and you didn't do a comprehensive search and you just didn't see it. But it may be someone that is just kind of throwing things against the wall to see what sticks. Maybe they're actually thinking, wow, that's a great name. I don't want them competing against me. So they try to make arguments to say that you can't do it. And we'll analyze that and make sure, decide if they're right or if they're wrong.
That's interesting. That's like, hey, wait a minute. I thought I was all good. The examiner finally made it through that argument. Now I got someone else opposing my brand and my application and my registration.
Mm-hmm.
And yeah, it definitely does happen where there's like another brand out there that maybe have common law rights. Maybe it didn't come up to the examiner. So the examiner is only searching inside the USPTO. Maybe they've got common law rights. They've been in business for 10 years using that brand. And if it didn't run a comprehensive search looking at everything, it may not have come up. A search is good, but it's not, 100%. Things do exist out there that, even AI doesn't find. So it is a possibility that someone else could come along and oppose your brand after that publication. And it's a 30-day publication period. Someone's got to file the opposition within that 30 days. And then you have a chance to read why, go through the process. They file something. They're explaining to you why they feel your brand shouldn't be registered. And we have the right to argue back. It's another hiccup, but it doesn't necessarily always stop you from going to registration. A lot of times you can either work around, yeah, you're a different trade channel, similar name. Yeah, you've been working longer, but you're only selling in Montana. I want to sell on the internet all over, the United States. Maybe we'll work on a consent agreement together or something along those lines. Not to pick on anyone from Montana. That was not the purpose. All right. We've made it through this far. We've now gone through publication. We've gone through opposition. There's no one opposed our brand. We waited those 12 weeks. We're registered. Does our trademark protection that's it? We've got it. We're done. We need nothing to do, nothing more.
Wouldn't that be nice? So no, once you're registered, there are regular intervals in which you have to maintain your trademark registration by filing renewals, by filing proof that you're continuing to use the mark as registered, things like that. And you also have to protect your brand by watching out for other companies that may be starting to infringe on you or even blatantly stealing your name. It's important we call that policing or watching your brand. It's important to do that because you can actually lose your trademark rights if you sit idly by and allow other companies to use your mark. You might be asking, how do I police my brand? What does that process look like?
Do it a couple of different ways. There are watch services that are provided that make sure they're looking at the USPTO. They're looking at applications that are filed in the USPTO. It's the easiest to stop another company when they're just getting started. So if they filed a new application and that application is within the same class, similar description of yours, and their name is confusingly similar. Remember, it's not exact. It's confusingly similar. Would the consumer confuse my product or my service for their product or their service? That's really the standard. If we catch it at the very beginning, when a company is just getting started, they just filed their application, it's a whole lot easier to send them a cease and desist letter telling them that we exist, we have priority, we have a trademark, and ask them to stop and rebrand. Give them a bit of time, ask them to withdraw their application or abandon their application and rebrand their company. We do that, through a legal process and go through that. But at the very beginning, if you catch it early, it's much easier to stop another brand from infringing on yours. But beyond infringing on that brand, they're also infringing on your reputation. They're working off of your goodwill. They're stealing your clients and your customers. It really does create a problem. Even beyond watching the USPTO and looking at other applications, you want to make sure that you're checking up out there what else exists. It doesn't end, like you said, right at the time that you get your registration. You want to make sure that you're continuing to monitor social media and other things for things that could be confusingly similar to your brand. It's a competitive world out there. We don't want someone else using our goodwill, our reputation to build their business. So we've talked about a lot of ways on how to get a proper registration, make sure that we're doing it properly, make sure we're not opening ourselves up to infringement, because if we don't run a search, we could be the ones infringing, and we could file an application and be getting that cease and desist letter because someone else is policing their brand. So we want to make sure we get the search done. We don't want to infringe. We want to make sure that we're building this foundation that we can continue to build our brand on, and someone's not going to stop us partway through it. We want to make sure that we get the right classes, the right description, so we don't have to pay additional fees. We don't have to do the application again, because that also is such a waste of time. Having to wait that time, rebrand, go through that cost, it's expensive and it's a time waster while you could be building your business instead of rebranding your business. If you want more specifics, you want to ask us questions, you want to go through it with us, we are always happy to answer the phone. We're always happy to talk to clients and see how we can help them build their brand. You can connect with us on social media. You can, in the comment section, there'll be a link to our website. You can always schedule an appointment directly through our website. So that way we can get a chance to talk to you, talk about your brand, work towards securing that brand. I'm Melissa Jeda.
I'm Holly McFall.
And this has been Securing Your Brand with SecureMark Legal.
Join us as we explore trademarks, copyrights, and intellectual property to ensure the protection of your creative assets. While we are lawyers, we are not your lawyers. So nothing contained in this podcast creates an attorney-client relationship or constitutes legal advice. The views and opinions of guests on our show are not necessarily those of SecureMark Legal and are provided for informational and educational purposes only. This presentation is protected by U.S. and international copyright laws. Reproduction and distribution of the presentation in whole or in part without written permission of SecureMark Legal is prohibited.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.